Look at the essay portion of our pretest. So this is the premarital agreement on unconscionability in Alaska. And really what we're looking for is going through the steps of browsing, linking, searching, and updating so that you can say these are all the mandatory Alaska cases that we've found. These tools should go off of each other and you should be able to say, oh, I have found this case multiple times. This must be a leading case or the only case or one of the leading cases. So we want you to find the cases in as many different ways as possible. And so for a full answer, you're going to want to go through browsing, linking, searching, and updating. So as we look through what we want all mandatory Alaska case law. We're going to provide a bulleted list of those cases, a brief statement of their relevance, and then whether they're good law. Then you're also going to provide a research trail that identifies all resources, consulted tools used in any search or index terms employed. So you are going to create a research trail, even if you have dead ends or if you find the same case multiple ways. Tell me about it so that I can see that in your research trail. Here is my list of cases. I have 2 cases. I have Andrew v. Abbey, and then I have its citation out of Alaska in 2021. I have a sentence about what it is about and how it has to do with unconscionability. And then I have a statement on my updating. Had a yellow flag on Westlaw, it's green on Lexis, it's still good law. My second case is Kilkenny v. Kilkenny out of Alaska, 2025. My statement on this is that it cites Andrew on unconscionability. I don't need more than that. It's not saying anything new, but it is citing Andrew. And then there's no negative treatment on Westlaw or Lexis. So it needs all 3 of those parts, the case, a statement about it, and then whether it's still good law. The next part is the research trail. I'm going to start my research browsing because what I'm ultimately trying to do is find one good case. So I start with browsing, and I can browse either with a secondary source, a key number, or a notes of decision if I'm given a statute. Here, probably a secondary source or key numbers will be helpful for you. The first thing I did is I started looking for an Alaska Legal Research Guide. I went to Georgetown's Alaska Legal Research Guide, but there is no state-specific resource. So if I'm going with secondary sources, to me that means I can go to AmJur. And if I go to AmJur, I can look up prenuptial agreements on fairness, one good case, and then look at Hall v. Hall. So let's go ahead and do that. I'm going to go to jurisprudence, select AmJur, go to the index, and premarital told me to go to prenuptial agreements, so let's try that. And now I'm in prenuptial agreements. So I'm going to look down this list. I might start with unconscionability. There wasn't anything on unconscionability. However, fairness is that kind of opposite of unconscionability. So I'm going to start there in the generally section and see where it is that I can go forward with my research. Here under the fairness standards of premarital agreements in general, I see that there is this, it must be fair and just, fair and equitable, fair and reasonable, or just and reasonable, not unconscionable. And I have a footnote for not unconscionable. So here is that term unconscionable within premarital agreements. Whatever case I find here is probably going to be good enough to start my research. So I can select 9, and the first one is Hall v. Hall, but then I have several others that I could have chosen. I'm going to go ahead and say Hall v. Hall is going to be my one good case. So you can see that here, Westlaw, AmJur, prenuptial agreements, fairness, one good case, Hall v. Hall, and then what it is. The other way that I could do that would be to start with key numbers and look to marriage and cohabitation, which is key number 253, then look at premarital agreements, and then 170 is on unconscionability. Change my jurisdiction to Alaska and see what I find there. Let's go ahead and look at that. Here I am in Westlaw, key numbers, marriage and cohabitation, key 253. And then I look through the list for things that sound right. So here are agreements concerning marriage, and premarital agreements is key 161 through key 200. So I'm going to select that. And here we have unconscionability. Now notice I'm in California, so I'm going to go ahead and change that. And I can change it from California, and I can change it to all states and all federal, just looking for one good case. Or since I know my jurisdiction is Alaska, I can go ahead and apply that. So now I have Kilkenny v. Kilkenny and Andrew v. Abbey. Do those sound familiar? So we have found the two main cases through this, but we don't know that they're the two main cases because we're still at the very beginning of our research. So I can write down Kilkenny v. Kilkenny as my one good case, or Andrew v. Abbey. So either of those, either going through the secondary source or going through key numbers, either of those browsing techniques are acceptable and get you in that moving forward in that direction. So the next thing I'm going to do is take Hall v. Hall. I'm going to go sideways or head note 1 and look for that key number and move myself into Alaska jurisdiction. So I'm going to take Hall v. Hall. I'm going to read through my head notes, and this one about marriage and cohabitation talks about unconscionability. So I can take that and select 253 key number 168 and see what I find from there. From here, remember, it's going to go into the jurisdiction that I was in originally. I'm going to change that to Alaska. And now I get Kilkenny, I get Andrew, I get Compton, and I get Brooks. And so I have two new cases, Compton v. Compton and Brooks v. Brooks, that I'm going to want to look more into in unconscionability. As I read through the two of them, I realize that Compton v. Compton doesn't really speak on unconscionability, and Brooks v. Brooks, the part about unconscionability is really dicta for that case. And so I probably wouldn't use either of these, nor would I say that they are mandatory on my subject matter. So what I've done here as I describe them is Compton v. Compton, no unconscionability, Brooks v. Brooks, and then I have Kilkenny and Andrew. So now I am in Alaska so that I can take these two cases, Kilkenny and Andrew, and go backward, forward, and sideways with them to find any more cases in Alaska about unconscionability with premarital agreements. So I'm going to take Kilkenny and Andrew and do the same process of backward, forward, and sideways. Let's just take Andrew and look at the process. Here I am in Andrew. I'm going to look at the head notes for unconscionability. It looks like head note 10 is about unconscionability. The first thing I'm going to do is look backwards, and I'm going to read about unconscionability. As I read through this paragraph, I see that it talks about unconscionability, and that is for and above, so it's for Brooks. We've already looked at Brooks. We've decided that that really didn't add anything or is mandatory for our search, but we have looked backwards. As I go forward, I can look and I see that key number 168, which is where I came from, but then we also have that 253 key number 170. So I can do that same process and find it. Remember, since I'm in Alaska, I don't have to change my jurisdiction here, and it gives me Kilkenny and Andrew. Then finally, I'm going to look at the 6 cases that have cited my case and see if any of them talk about head note 10. Here we have Kilkenny talking about head note 10. We have Mohammed v. Abir talking about head note 10, so I'll want to look at that. I have matter of estate of Eichstad talking about Head Note 10, but notice that it's out of South Dakota, so it's not going to be mandatory for me, so I don't need to look at it further. So the only case that is new that I need to make sure I look at is Mohammed v. Abir. It ends up that it does not have to do with unconscionability, so that I do not need to cite Mohammed. So I have now looked through all of these, and you'll notice when I look at Andrew, backwards Brooks, backwards Head Note 10, Brooks v. Brooks. Andrew sideways is the same as Kilkenny. Andrew forward Head Note 10, Kilkenny, Mohammed, no unconscionability, matter of estate, South Dakota. So I have all of that, what I've just discussed, written in my research trail. So I have now linked forward, backward, and sideways with all of the cases that I have. My next step is to search. The thing I'm going to do first in my searching is come up with keywords. So I'm going to use our ladder of abstraction and come up with multiple words and concepts that I all need in my search. So the first idea that I need in my search is the idea of a prenuptial agreement. The next idea I need is unconscionability, and then that third thing might be divorce. So I'm going to come up with multiple keywords for at least one of those words, and prenuptial agreement is the most likely. I looked up a whole lot of words: antenuptial, postnuptial, separation agreements, cohabitation agreements, marriage contracts, premarital agreements, spousal agreements, domestic contracts, matrimonial contracts. All of those terms, if I got anything back on those that talked about unconscionability, I probably would be able to use that within the search. I've decided that a field search will be my best idea, so in my ORs, I'm going to put all of the different ideas of prenuptial agreement, and then in my synopsis digest, I'm going to put the word unconscionability, or unconscionable with exclamation point. Remember, I'm going to go to cases, and then I can go to advanced. I'm in Alaska. And then any of these terms, I'll put all of those terms. And then in my synopsis digest, I'll put unconscionable. Now, make sure you've told me exactly what you've searched, and so you can just highlight this and stick it into your research trail. I get 12 cases when I do that. Kilkenny, not surprised to see that. Not surprised to see Andrew v. Abbey. But then all of these next cases, I'm going to need to look through them and decide what do they have to do with these terms. Is this something I'm interested in? So this first one, Riddell v. Edwards, is about unconscionable postmarital conduct, not to do with an agreement. So I don't need to look at Riddell. Horton v. Horton has to do with an unconscionable contract, but it is a partnership agreement that is a partnership agreement for a corporation or a partnership, an LLP. So that does not have to do with what I'm looking for, so I don't need to use Horton. And it ends up that the rest of these all have to do with unconscionableness and agreements outside of the world of marital agreements. So again, those two cases that I found are the two main cases. So I've written what I found: Kilkenny, Andrew, Horton v. Horton was a partner agreement, and then several others, but not on point as the type of agreement or agreements outside of marriage. So that is all I need to say. If I found additional cases, I would put them here. And then finally, updating. Make sure you update on both Westlaw and Lexis. You're going to take those cases and put them into both and then see what kind of treatment they have. So we have Andrew v. Abbey. It has a yellow flag. So we can look at it, look at Haviland v. Haviland, and see what that negative treatment looks like. We used Abbey v. Abbey for Head Note 1, or Head Note 10. And here it is, Head Note 36 is what Haviland v. Haviland is. So I'm not as concerned. We can read about it. It's about contract, weight, and sufficiency, but not unconscionability. So I feel confident that this negative treatment would not change or sway the court in any way, that I can still use I can use Andrew v. Abbey for unconscionability of premarital agreements. I would take this, and now I'm going to look it up on Lexis. and I see that it has a positive treatment, so I don't even have to worry. At this point, I know that Andrew v. Abbey is good. And then the next one is Kilkenny. So I'm looking at Kilkenny. Kilkenny has no subsequent history, so if I shepherdize it, I don't need to. I know that it is still good law here, and then I can look on Westlaw at Kilkenny. And Kilkenny has no negative treatment. So those are both good. I will write that in my research trail. Kilkenny, Westlaw, no negative treatment. Lexis, no negative treatment. Andrew, Westlaw, yellow flag, not on point to issue about separation agreements and duress. Lexis, positive treatment. And then the final step, even though it was the first step, is to then list those cases. So we have Andrew and Kilkenny, that short sentence about why it's important, and then your updated, is it still good law? Good luck on your quiz, and if you have any questions, please feel free to email.